2, there is a boy named Marcus who goes to a farmer's market every Saturday morning and sells honey. He keeps bees now. He has kept them for 2 years. He tends 11 hives on a half-acre lot behind the house where he lives with his grandmother. He is 14 years old, and he started this because a sentence I wrote gave him the option to. That is where I want to begin. I want to tell you how we got there. Subscribe before I keep going. Not because what I am about to tell you is dramatic, because it is the opposite of dramatic, and those are the stories that need the most people to hear them. Subscribe and turn on notifications, then let me continue. The case file came to my desk on a Tuesday in February. It was a civil complaint, medical malpractice, and intentional infliction of emotional distress, filed on behalf of a minor child by his mother, Denise Okafor. The defendant was Dr. Raymond Spiller, age 57, a board-certified pediatrician who had been practicing for 26 years. The practice was in a suburb of Columbus, Ohio. The incident it described had occurred on September 14th, 14 months before it reached me. The child named in the complaint was 11 years old. I read case files the way I have always read them, front to back, no skipping, no previewing the end to see where it lands. I have learned that the shape of how a thing happened matters as much as the fact that it happened. By the time I finished reading this one, I had written 3 words in the margin of the last page. The words were, "Who is he?" I was not asking about Dr. Spiller. I was asking about the boy. I want to tell you who Marcus Okafor was when he walked into my courtroom on May 7th. He was 12 by then. He was wearing a blue button-down shirt that was a size too large and dark pants that had been pressed, and I noticed the pressing because it is the kind of detail that only a person who cares about being taken seriously would think to do, and when I see it in a child, I pay attention to it. He sat in the gallery with his mother and his grandmother, and he kept his hands folded in his lap the entire morning. He did not fidget. He did not look around the room the way most children do when they encounter a courtroom for the first time. He looked at the front of the room, at the bench, at the witness stand, at the seal on the wall, like he was studying it, like he was deciding what he thought of it before it had the chance to decide what it thought of him. That is who he was. 12 years old, dressed carefully, studying a room that was about to hear what someone had done to him. I want you to hold that image because it stayed with me through every hour of testimony that followed. Dr. Raymond Spiller walked in 20 minutes after the Okafors did. He was tall, wore a gray suit, moved with the particular kind of ease that comes from having been the most credentialed person in a room for most of your professional life. His attorney, a man named Gerald Hatch, walked next to him. I watched Dr. Spiller take his seat at the defense table. He arranged his papers. He adjusted his tie. He did not look at the Okafor family. I noticed that he did not look at them, and I held that noticing without weight, the way I try to hold all early noticing as information, not conclusion. What happened on September 14th was this. Marcus Okafor had a 10:30 a.m. appointment at Spiller Pediatric Associates on Kendall Road in Westerville, Ohio. It was a routine annual wellness visit. Marcus was 11 years old, 4 feet 11 inches tall, and weighed 187 pounds. He was in the examination room with his mother. Dr. Spiller entered at 10:47. He reviewed the chart, checked Marcus's vitals, conducted the standard examination. Then, according to both Denise Okafor's testimony and the testimony of Marcus himself given in a recorded deposition that was entered into evidence, Dr. Spiller turned to Denise while Marcus was still seated on the examination table and said, "You understand that this child is severely obese. At this rate, he will be diabetic before high school. Whatever you are feeding him, it is not love." He said it the way someone says something they have said before, without pausing, without adjusting for the fact that the child was in the room and could hear every word. Marcus said nothing. Denise Okafor said nothing. Dr. Spiller moved on to discuss dietary referrals. The appointment ended at 11:09. They drove home in silence. In his deposition, taken 8 months after the incident, Marcus was asked how he felt when he heard those words. He said, "I knew I was heavy. I didn't need him to tell me. I just didn't know it made me less loved." He was 11 years old when he said that. I read it in the deposition transcript 4 times. I want you to understand something about that sentence. It is not the sentence of a child performing injury. It is the sentence of a child who had been working out a very specific confusion, not about his weight, but about what his weight meant about the people who fed him, and whether feeding him meant they loved him, and whether a doctor in a white coat had the authority to answer that question without being asked. He had been carrying that confusion for 8 months before he put it into words. That is what was in the complaint on my desk. Subscribe before I go further. Cases like this one do not happen as often as they should, and they deserve to be documented and heard the same way the harder ones do. Subscribe so you are here when I get to the part that made me remember why I chose this work. The legal mechanism available to me in this case was one that not every civil proceeding makes room for, and I want to explain it plainly because it is the reason the sentence I eventually gave was possible. In Ohio civil courts, in cases involving harm to a minor, a judge has the discretion to order remedies that are not strictly financial, remedies that address the specific nature of the harm and the specific capacity of the defendant to address it. This is not a technicality. It is a recognition that the law sometimes knows that money is not the only language in which harm can be answered. I was glad to have that tool in this case. I knew from the first reading of the file that a fine paid to a trust account was not going to do the specific work this case required. I needed to be able to require something more precise. I also need to tell you about Gerald Hatch's preliminary motion filed 3 weeks before trial, which argued that Dr. Spiller's statement was a medical opinion delivered in a clinical context and was therefore protected under the standards governing physician communication. I denied that motion. I denied it because the statement as recorded did not meet the clinical communication standard. It was not addressed to the patient. It was not framed as diagnosis or treatment guidance. It was addressed to the parent while the patient was present, and it contained a comparative judgment. Whatever you are feeding him, it is not love. That has no clinical meaning and was not contained in any treatment note from that visit. I want to be clear about that. I denied the motion because the evidence did not support it, not because I had already decided how I felt about the case. I had not decided how I felt about the case. Denise Okafor walked to the witness stand on the morning of May 8th, and I watched her from the bench and I paid attention to the way she walked. She walked carefully, the way a person walks when they are afraid of dropping something. She took her seat, adjusted the microphone, and looked at her son in the gallery before she looked at the plaintiff's attorney. She looked at him for 2 or 3 seconds, not for comfort, I thought, but to check, to make sure he was still okay. I saw that and I understood something about what this case had been like to carry. She testified for 3 hours and 40 minutes. She was a precise witness. She did not exaggerate. When the defense asked her on cross-examination whether she had considered that Dr. Spiller may have been acting out of genuine medical concern, she said, "I know he was concerned. I was not there because I was angry that he was concerned. I was there because of the way he said it in front of my son. A doctor can be right and still cause harm." I wrote that down, not in the margin this time, on a fresh page. Subscribe before I continue. I have been building to something in this story, and it is not where you might think it is going. Subscribe and let me get there. Turn 1 came on the afternoon of May 8th, from a person I had not expected it to come from. Dr. Spiller took the stand at 2:15 p.m., and his attorney walked him through the standard sequence, his credentials, his years of practice, his clinical reasoning on the day in question. He was composed, thorough, careful. Then the plaintiff's attorney, a woman named Sandra Reyes, stood up for cross-examination. She asked him one question that I do not think Gerald Hatch had prepared him for. She said, "Dr. Spiller, do you have children?" He said yes. She said, "Under how old?" He said his daughter was 9 and his son was 13. She said, "If your son's doctor said something like that to him in a room where he could hear it, what would you want to happen next?" Gerald Hatch objected. I sustained it on technical grounds, but the question had already done what questions sometimes do. It had been heard, and the hearing of it had changed something in the room. What changed was Dr. Spiller. He did not speak, but for approximately 4 seconds before the objection was sustained, he did something I have seen very few defendants do on the stand. He stopped defending. He sat there, and for 4 seconds he was not a physician with 26 years of experience and a pending malpractice case. He was a father thinking about his 13-year-old son. I watched it happen from the bench, and I did not look away, and I did not rush past it. That 4 seconds told me something true about who Dr. Spiller was underneath the composure. It told me he was capable of understanding what he had done. It did not excuse what he had done, but it told me something that changed how I was reading everything else. That was turn one. Turn two came the following morning from a piece of evidence submitted by the plaintiff's attorney that I had reviewed in the file, but whose full weight I had not yet understood. It was a letter. It had been written by Marcus Okafor on January 9th of that year, 3 months before the trial, and submitted voluntarily to the court by Denise Okafor's legal team as part of the evidence package. It was not a letter written for legal effect. It had been written as a school assignment. The assignment was to write about a problem in the world and what you would do about it if you had the power. Marcus had written about what doctors say to children when they are heavy. He had written 4 paragraphs, each careful and specific. The 4th paragraph ended with this sentence: "I think doctors forget that kids are listening, and that what they hear in that room is what they believe about themselves for a long time after they leave." He was 12 when he wrote that. It was a school assignment. He was not performing wisdom. He was doing homework, and the homework had asked him about a problem in the world, and this was the problem he knew. I read it twice from the bench, and I looked up at him in the gallery. He was doing what he had been doing all morning, watching the front of the room, hands in his lap, deciding what he thought of it. I made a decision in that moment about what this case required. Not a sentimental decision, a structural one. I knew what the sentence needed to do. I'm about to tell you the full sentence. I'm about to tell you every part of it and the reasoning behind each part. Subscribe before I do, because I want to explain every part of it, and the explanation is as important as the ruling itself. Subscribe now. On the afternoon of May 14th, a Thursday, I convened the courtroom for the verdict and sentencing. The room was quiet in the specific way rooms are quiet when people are waiting to find out whether something fair is going to happen. Marcus was in the front row of the gallery, still in the blue shirt. Dr. Spiller was at the defense table. His hands were flat on the table in front of him. I had made this decision carefully. I had made it knowing that mercy, to mean anything, has to be precise. Vague mercy is just hope. Precise mercy is a plan. I had a plan. I found for the plaintiff on both counts. I found that the statement made by Dr. Raymond Spiller on September 14th constituted intentional infliction of emotional distress under Ohio civil standard, and that it caused documentable and ongoing harm to a minor child. Then I spoke the sentence. I said, "I am ordering you to pay restitution in the amount of $22,000 to a counseling trust fund in the name of Marcus Okafor, to be administered by Denise Okafor and used solely for therapeutic services of her choosing for as long as Marcus requires them. This is not a fine. This is not a punitive number chosen to hurt you financially. It represents 3 years of weekly therapeutic access at current market rate, and it is going there because the harm you caused was specific and the remedy should be equally specific. I am also ordering you to complete 120 hours of mandatory continuing education in pediatric communication and weight stigma counseling, certified by the Ohio State Medical Board within 18 months of today. You have 26 years of skill in this profession. I am not asking you to stop using them. I am asking you to add to them. The evidence in this case showed me that the gap in your practice is not clinical. It is communicative. That gap can be filled. You have the capacity to fill it. There is one more thing. I am ordering you to write a personal letter, not a legal document, not a communication from your attorney, a personal letter, addressed to Marcus Okafor, to be delivered through plaintiff's counsel within 90 days. That letter must be written by you, in your own words, without legal review, and it must contain one specific thing, an acknowledgement in plain language of what you said, who was in the room when you said it, and what you understand about the effect it may have had. You do not have to ask for forgiveness. You are not required to ask for anything. You are required to see him. That is all that letter needs to do. See him. I also want to name a condition. If Dr. Spiller completes the 120 hours of continuing education within the first 12 months rather than 18, I will reduce the supervised reporting requirement from quarterly to annual. I name this not as a reward. I name it because I believe he is capable of doing this well, and I want the structure of this sentence to reflect that belief. I am going to tell you what I said from the bench before I closed. I have thought about these words since that day, and I want to say them again here as plainly as I can. I said, what you said on September 14th was not a clinical assessment delivered poorly. It was a judgment about a child's family delivered to a parent while the child was listening, and it entered that child's understanding of himself in a way that a prescription pad cannot reach. The people who fed Marcus Okafor did so with love. They fed him and dressed him and pressed his shirt and drove him to your office because they were trying to keep him well. That is not neglect. That is imperfect, ordinary human love, the only kind that exists. You reduced it to a failure in front of the person it was most meant to protect. I also said I have read what Marcus wrote about what doctors forget. I believe he is right. And I want you to know that a 12-year-old child with no legal training and no advocacy organization behind him produced in a school essay the clearest articulation of the harm in this case that I encountered in 4 days of proceedings. That is not an accident. That is who he is. And then I looked at Marcus directly and I said, I see you. This room sees you. Whatever you heard in that office on September 14th, whatever it made you think you were worth, I want to tell you that this courtroom today has produced a different answer. He said, and this is the quote I wrote down on the fresh page, the one I wrote down not because I needed to remember it, but because I wanted to. He had said it in his deposition, and I had read it so many times that when I said those words from the bench, his face did not show surprise. It showed something quieter than surprise. He nodded, once, small, like a person who had been waiting a long time to hear something, and when they finally heard it, found that it was exactly the right size. There is a memory I carry from before I was a judge, from when I was 23 years old and my younger brother was in a hospital in Cincinnati for 3 weeks with a condition nobody could name. He was 8. I drove 4 hours to be there every weekend, and I sat in the hallway outside his room because they only allowed 2 visitors at a time and my parents were always in the room. One afternoon, a doctor came out of my brother's room and walked past me, and I asked him how he was doing, and the doctor said, without stopping, without turning fully toward me, "We're managing it." That was all. We're managing it. I sat in that hallway for another 2 hours, not knowing what managing it meant, or whether managing it was good, or whether my brother was frightened inside that room. I have never forgotten the cost of those 2 hours. I have never forgotten what it felt like to be standing in a hallway full of information that someone had decided I did not need. I do not tell this story as a lesson. I place it here next to this case because it belongs here. That is all I know how to say about it. Thank you for staying with this story. It is not the kind of story people usually tell about courtrooms. Subscribe if it is the kind of story you want more of. I have more to tell. No appeal was filed. Gerald Hatch sent a letter through the court confirming that Dr. Spiller would comply with the sentence. I noted the absence of an appeal when I received that letter, and I held it for a moment before I filed it. It told me something. I am not going to overstate what it told me, but it told me something. What I know happened after is this. On August 19th, 11 weeks after sentencing, a letter arrived at Plaintiff's Counsel's office addressed to Marcus Okafor. Sandra Reyes called my clerk to let her know it had arrived. My clerk told me. I did not read the letter. It was not mine to read. But I know it arrived on August 19th, and that Denise Okafor received it, and that she called Sandra Reyes afterward and said one thing. She said, "He saw him." That is what I know happened. And on a Saturday in October of the following year, a boy stood behind a folding table at the farmer's market on 5th Street in Westerville with 11 jars of honey and a handwritten sign that said, "Marcus's Bees, Wildflower and Clover." He had started the hive 7 months earlier as part of a requirement I had included, loosely worded, in the structured portion of the sentence. a requirement that Marcus be provided with access to at least one extracurricular program of his choosing funded from the restitution trust with the goal of building something rather than managing something. His grandmother knew a man who kept bees. He went once to watch. He went back the following week. The week after that, he started asking questions and did not stop. I sat in enough hard rooms over enough years to understand that what a courtroom builds or destroys is not only a case, it is a story a person tells themselves about whether they were seen. That is not a sentiment. It is what I watched happen over and over in the years I spent behind that bench. The people who carried themselves out of those rooms differently were almost never the ones who received the most severe consequence. They were the ones who believed, when they walked out, that someone in that room had been paying full attention to who they actually were. That is what I was trying to do when I designed that sentence. I was not trying to be lenient. I was trying to be accurate. The distinction matters. To anyone who has been in a position like Dr. Spiller's, who said something real, who caused real harm, who did it without malice, but caused it just the same, I want to tell you what I look for from the bench. I look for the moment when a person stops explaining and starts understanding. It does not have to be dramatic. It does not have to be tearful. It does not have to be anything but honest. 4 seconds of honest understanding is enough for me to know that the capacity is there. If you have that capacity and you are carrying harm you caused and wondering whether there is a way through it, the way through it is not a lighter sentence. The way through it is doing the specific work of seeing the person you did not see clearly enough when it mattered. You can start that work before anyone orders you to. To anyone who has been in Marcus's position, who was sitting in a room where a person with authority said something about them that entered them like a fact and has lived there ever since, I want to tell you what I witnessed from the bench when people like you chose to come forward. I am not going to tell you what to want from that process. I am going to tell you what I saw. I saw people leave those proceedings differently than they entered, not because they got everything they asked for, because someone in an official room listened carefully and confirmed, with the full weight of the institution behind them, that what happened to them was real and mattered and had a name. That is what courts can do when they are paying attention. They can name things. Sometimes naming is the beginning of everything else. Subscribe. I am not going to make a speech about it. You are already in this story. Subscribe and let me finish. There is a boy named Marcus who sells honey on Saturday mornings at a farmer's market on 5th Street. He is 14. He tends 11 hives. His sign is handwritten. He was 12 years old when he sat in my courtroom in a pressed blue shirt and studied the room like he was deciding what to think of it before it had the chance to decide what to think of him. That is why I told you this story. A single beat. If you want to hear the others, and there are others, subscribe. That is all I am asking. Subscribe and stay. And if you have something to say about what justice looked like in this room, the comments are open. I read carefully. Come in the same spirit this story was told in, not looking for the worst of what courts do, but willing to sit with one of the better things. Marcus. Anyone who has ever made Dr. Hale's calculation, not necessarily in medicine, not necessarily with those stakes, but in any situation where you ran a number before you ran to help,